So let's start with the topic. The first topic of the day is the Supreme Court verdict on governor assent to the bills, right? So let me make clear to you that in the current affair class, there are two kinds of students are sitting. Like first one is beginners and second one is who has already prepared or who has already gone through the GS foundation classes and so on, right? So we will cover A to Z of the topic. We will start from the basics, then understand the current affair issue, then we will discuss its analysis and so on, right? And whatever topic we will discuss will be relevant for both your prelims and mains. So current affair will be covered in integrated fashion. Third thing, when we are covering basics, it will be a revision for the all students, right? And when we cover the basics, it will be an opportunity for the new students, for the beginners to understand the concept. How the beginners will get benefited, like first you will understand the topic in the current affair, then the same topic, the same basics will be covered in your static class. So there your idea or the concept will get reinforced. If you have understood it in your static class already, then what we will discuss in the current affair class will again reinforce or consolidate your concept. And whatever the basics we do, it will be a quick revision for the all students, right? Clear? So let's start. The issue or the current affair news was that Supreme Court has given a verdict, a very important verdict, regarding governor's power with respect to assent to the state legislative bills, right? So what is this judgment? We will discuss later. First, we will cover the basics. Clear? So first, there are certain issues in the functioning of office of governor. So governor, as you know, is head of state, chief executive head of the state. And who is the real head of the government at the state level? CM. So governor is supposed to act on the aid and advice of council administered by CM. But governor has been given certain discretionary power by the constitution. And discretionary power means governor will act on his or her own without the advice of council administered by CM.
Excuse me, sir.
Yes.
Sir, please share the screen.
Do I need to again share it?
Yes, sir. We can see you, but the screen is not visible separately.
Okay, just wait. Yes, online students, please confirm.
Yes, sir.
Audio video slide clear?
Yes, sir. Thank you.
Okay. So governor has been provided certain discretionary power, but many times what we have found that governor has misused its discretionary power. So we all know about how governor misuses his power. So we'll take some current examples where governor has misused the power. Like Uttarakhand in 2016, president rule was recommended by the governor, despite the fact Congress government at that time has the majority or could prove the majority in the house, because there was 70-member MLA, 70-member Legislative Assembly of Uttarakhand. Congress has that time 36 MLA. 9 has been switched to BJP. All right. Still Congress say, I could prove majority in the house, but without giving any opportunity to Congress to prove the majority, governor recommended president rule. In Delhi, you have seen Lieutenant Governor has frequent clash with CM Kejriwal, former CM Kejriwal. It is the CM who should have the authority to promote or to post the civil servants, right? To suspend the civil servants and so on. But the Lieutenant Governor start exercising that power. If Lieutenant Governor start exercising the power, then bureaucrats will not listen to the CM because they knew that they can't be suspended or transferred, etc. by the CM. So the civil servants will become accountable to whom? Lieutenant Governor, who was working on the directions of central government. Right? So the democratically elected government of Delhi will not able to function effectively. In West Bengal, the governor started appointing vice chancellors in the universities. Start publicly criticizing or rebuking the Mamata Banerjee government functioning. That was against the constitutional spirit because vice chancellors are supposed to appointed on the advice of council decided by CM. The governor is not supposed to publicly rebuke or criticize the government because the West Bengal government is actually the governor's government. The Mamata Banerjee government is actually the governor's government because all the executive actions of the state government are taken in the name of governor. So he or she, the governor cannot humiliate his own government publicly. Clear? Then in Arunachal Pradesh, again governor role was questioned. How? In Arunachal Pradesh, what happened? There was Congress government. Governor on his or her own has invited the session of the State Legislative Assembly of Arunachal Pradesh. See, the such session has to be called on the advice of council administered by CM, but it has been called by the governor on his own. Why? There was the specific reason of toppling of removal of Congress government. So to install BJP government there. How? The certain MLAs of Congress again switched to BJP. So the session was called. First, the speaker was removed. Right? Then new speaker was appointed, elected. That was basically of BJP. The earlier speaker was of Congress. The new speaker was of BJP. Then the confidence motion was brought in. Confidence motion was brought in. So to prove the majority of a leader of BJP. That's how all these things happened. So again, the matter goes to Supreme Court. Supreme Court says governor cannot exercise such power on his or her own. Right? Clear? So these are some recent examples where governor has misused the power. Now coming to the constitutional provisions relating to assent of the bill by the governor. So there is an article 200 which says if the bill is passed by state legislature, it shall be presented to the governor for the assent. So governor has 4 options there. First, assent to the bill, or withhold the assent to the bill, or return the bill to the legislature for reconsideration, and reserve the bill for president consideration. Right? If such bill is endangering the power of or position of High Court, then it's mandatory for the governor to reserve the bill for president consideration. But it is discretionary to reserve the bill for president consideration if such bill violates the constitution or affects the national interest, is of grave national importance, or deals with compulsory acquisition of property under Article 31A. Right? So far, so clear. Now, under Article 201, President has 3 options: either gives the assent, or withhold the assent, or send back the bill for reconsideration for state legislature. And state legislature has to pass the bill again within 6 months. And now, in the second instance, is President bound to give the assent? No. In second instance, President is not bound to give assent to the state legislative bills. President is bound to give assent in the second instance in case of parliamentary bills. Clear? So that distinction you need to remember. So far, so clear? That was the actual constitutional provisions regarding the assent to the bill. So now you have understood what were the constitutional provisions relating to assent to the bill. Now you have understood that governor office was being misused. Now coming to the point, how the governor office was being misused for assenting the bill to the state legislative bills. Right? So it has been found that governor has been keeping the bills pending for a long period of time. He was not giving the assent to the bills passed by the state legislature, especially in the states which were ruled by opposition party. For example, in Tamil Nadu, in West Bengal, etc. Or what the governor was doing, he was reserving the bill for president consideration. And then president will be taking very long period of time to give the assent to the bill. So what was the result of these delays? First, the governance of the state get affected. You will not able to administer the state efficiently or effectively. Then the people of your state will get angry with you. Then the opposition party will face the wrath or anger of the people in the next election. They will lose the election. And this creates the chance for the BJP to come into power in the opposition ruled states, just like it happened in Delhi. So there was a political objective behind the delay of the assenting to the bills, right? It undermines the state autonomy because state government cannot have its own bill get passed in the state legislature, get assented and get start implementing those bills. It is reducing this legislative supremacy because what the state legislature has decided through law has been vetoed by governor. So it's the unelected governor who is taking the call, not the elected body named state legislature. It is disregarding the democratic process because in democracy, the people's representatives should decide, not the appointed official, that is governor. Then there is no transparency and accountability. Governor never lists out the reason why he is withholding the assent or reserving the bill for president consideration and so on. Even he specified such grounds many times appear flimsy, right? Then public perception, the public trust over the both state government and central government get reduced. People will think that neither state government wants to function nor the central government. Clear? So what will be the ultimate consequence? The people trust over democracy will get reduced. The democracy is not functional in the country. Democracy will not yield any result. Democracy just have delays and delays and delays. Clear? Now coming to the Supreme Court verdict. Supreme Court says that governor does not have any absolute veto. It means governor cannot withhold the assent. It is provided by Constitution, but Supreme Court says you no longer have the withholding of assent power. Second, Supreme Court says you can't exercise pocket veto also. You know about the pocket veto? Where the governor can keep the bill pending for assent for indefinite period of time. So here Supreme Court is prescribing time limit within which you have to give the assent. So neither governor can withhold the assent nor can keep the bill pending for indefinite period of time. So within the specified time period, governor has to give the assent. Right? So what governor can do? Either give the assent or return the bill to state legislature for reconsideration. That's it. No withholding of assent, no pocket veto. How it will work? First, governor says, if you want to withhold the assent, or reserve the bill for president consideration on the advice of council which decided by CM, then you have to do it within 1 month. If you want to withhold the assent without or contrary to state council or minister headed by CM advice, then what maximum you can do? First, send back the bill to state legislative assembly for reconsideration. If such bill get passed, then governor has to give the assent to the bill within 1 month. So governor has to send back the bill for state legislative assembly reconsideration within 3 months. And after the bill again get passed by state legislative assembly, then governor has to give assent within 1 month. Right? Clear? How about the reservation of bill for president consideration? Supreme Court says that if it is relating to endangering the position or power of the High Court, then governor has to reserve the bill for president consideration, right? And if it is relating to violation of constitution or is relating to matter of national interest, etc., then if governor choose to reserve such bill for president consideration, that too within 3 months, then president has to act upon it within 1 month. Within 1 month. So basically, Supreme Court has prescribed timeline or time period, time limit for both president and governor. So here, the discretionary power of the governor has been curbed. Governor has just now, I think 3 options. First, assent. Second, send back for reconsideration within 3 months, or reserve the bill for president consideration. All right. And if the bill get repassed, then have to give assent to the bill within 1 month. And if reserved for president consideration, then president has to give the assent within 1 month. Right? Clear? Supreme Court has did one more thing in this verdict. What has happened? Tamil Nadu governor has reserved 10 Tamil Nadu state legislative bills for president consideration. 10. Not 1, not 2, 10. So the prime objective was to stop the governance of state of Tamil Nadu. Right? So what Supreme Court did? See, Supreme Court under 142, Article 142, has the power to give any kind of order. We will discuss in judiciary under 42 to ensure complete justice. Supreme Court can give any kind of order. Right? Any kind of order Supreme Court can give to ensure the complete justice. So in this case, what Supreme Court did, it says that I'm issuing the order under Article 142 that these 10 bills are deemed to get the assent of president. These 10 bills will be deemed of getting the assent of president. So president does not need to give the assent. We will assume that such bill has got the assent of president. Clear? Supreme Court does not even bother to order president to give the assent. Supreme Court says, we are assuming that such bill has got the assent of president. Clear? You get the clarity? And Supreme Court says, if governor or president delay the assent to the bill beyond the time limit prescribed, then state government can file the case before the Supreme Court and get the mandamus writ issued. That will be discussed in fundamental rights chapter. It's basically an order issued by Supreme Court to make sure that the public organization or the public official discharge its duty. The government body or government official discharge its duty. So if president or governor does not discharge the duty of giving assent to the bill, then who will make sure that such duty is discharged? Supreme Court. Right? Then under Article 161, the president and governor has been given legal immunity from any liability in court of law for discharging their official duty. So whatever they do in their office is immune from any legal action. Why? Because they do sworn aid and vice of council of ministers headed by PM and CM respectively. But here, governor has been asked not to take such legal immunity for granted. Both governor and president has been asked not to take such legal immunity from granted. You could be held accountable in court if you exercise your power malafidely. Right? Here, governor is exercising the power malafidely, deliberately, to prevent democratically elected government of Tamil Nadu to function, has reserved the bill for president consideration. Right? Clear? If president's satisfaction of acting upon the aid and advice of council of ministers headed by PM is of malafide nature, then such satisfaction could be challenged on Supreme Court. Clear? Clear? So what is the impact of Supreme Court judgment? It will strengthen federalism. Federalism how? Federalism means division of power between central and state government. So here, whatever the power has been given to state government, it will able to exercise. The center will not able to obstruct the state government to function. Clear? Through the office of governor by reserving the bill for president consideration. Clear? Second, the unnecessary delays will now be curbed, will now be stopped. Right? Third, the governor's discretion get limited, and it should be limited. Why? Because see, we need the governor office during the time of independence, the initial years after the independence, because the constitution was framed in the context of partition of India. So that's why we have the fear that state may get disintegrated from Indian Union. That's why we keep a center representative as chief executive head of the state in all the states, so that the governor could keep a vigil, monitoring over the state government functioning. Moment it sees that state government is functioning not as per the constitution, may be seeking separatism, etc., then governor will send report to the central government for imposition of president rule. But now tell me, don't you think that Indian Republic has been matured now? The Indian nation, Indian state has been matured now. We do not have any threat of separatism or successionism now. All the threats being posed by Tamil Nadu or the Punjab, or even now the Jammu Kashmir, earlier by Nagaland, Mizoram, etc., have been subsided, have been subdued. There is no such threat of separatism now. So don't you think the governor's power should be reduced according to the current context, the current situation? Right? So that's why discretionary power of the governor should be reduced. We should empower state governments. We should give more and more power to state governments. Constitution has given greater power to center, so that center could control the state government, so that state does not get separated from Indian Union. But now the time requires that state governments are, or state government should be more powerful vis-a-vis center, just like the arrangement is in USA. In USA also, states are more powerful than center. Or at least whatever the power we have given to center, whatever the power we have given to states, we should allow them to exercise it. Clear? At least the bare minimum we should do. Clear? Then judicial review could happen now. If governor unnecessarily obstructs the functioning of state government, then it will improve the governance, center-state friction or the conflicts will get reduced. And also it basically reinforce the basic structure of the constitution, that is democracy and federalism, where democratically elected government is not obstructed by an appointed official, that is governor. So democratically elected government should have greater say as compared to the appointed official governor, because democratically elected government has the accountability towards you. The party in power will answer the questions raised by you in the next election. But the governor, the unelected official, does not have any accountability to you, to the people. Clear? So that's how democracy get reinforced. Clear? But there is criticism of this verdict. What could be the criticism? First is in this undermining separation of power, because judiciary is encroaching upon the executive power. Judiciary is telling the governor and president how to give the assent, in what time period they have to give the assent. So judiciary is encroaching upon the power or jurisdiction of executive. What if vice versa is happened? Executive start telling judiciary that within such time period you have to appoint the judges, within such time period you have to transfer the judges, within such time period you have to resolve the cases and so on. Will judiciary tolerate it? No. Then why judiciary is interfering in the executive functioning? Clear? Second is gubernatorial discretion get limited. Gubernatorial means governor, right? Governor's discretion get limited here. So it could have adverse impacts. Right? Then fixing timelines is maybe arbitrary. How you decide that 3 months should be the time limit? It could also be 6 months. It could also be the 1 year, or maybe 2 year, or maybe 1 month. So on what yardstick the Supreme Court has a right that 3 months is the reasonable time period within which governor has to give the discretion? And don't you think judiciary is rewriting the constitution by its verdict? Has it been provided in the constitution that within such time period the governor has to give the assent or president has to give the assent? No. Here judiciary is rewriting the constitution. Clear? Then judicial review ambiguity. So if the governor does not give the assent within this specified time period, then it could be challenging Supreme Court, and Supreme Court may have plethora of cases being filed before it. And how this will work is also unclear. Will judiciary see just that whether the time period or time limit has been followed or breached, or will it see that the content of the bill, the substance of the bill? There could be two possibilities. Like governor does not give the assent within the stated 3 months, right? And you have filed the case before the Supreme Court, so to instruct governor to give the assent, right? So now the judiciary will see, and judiciary will see whether the time limit has been breached, and will just give the order accordingly that governor give the assent. Or judiciary will see the substance of the bill, whether such bill requires governor assent or not, whether such bill is blatantly unconstitutional, that's why governor was delaying the assent to the bill. If judiciary is saying that the said bill is blatantly unconstitutional, then it means Supreme Court is again encroaching upon the power of executive. That's the task of the head of the state, not the task of judiciary, right? Then again, it could disturb central state balance of power. It again disturb federal balance. How? So through this verdict, in whose favor the power has been shifted? Judiciary. If I ask you, that in whose favor the power has been shifted between center or state. Center. No, sorry, state. It has been shifted. The power has been shifted to states. Now, don't you think the center will allow such shift of power to state? No. Again, there is a possibility center may amend the constitution to either revert back to the old position or create a new position where center will have greater say. If center do this, then again there will be conflict between center and states, right? Then use of Article 142 for deemed assent of president is also being criticized. Why judiciary has exercised such power under Article 142? It could have given time to president, like say 3 months or 6 months, etc., within which it has to decide whether to give assent to the bill or withdraw the assent to the bill. But Supreme Court has exercised extraordinary powers under Article 142, where it says the bill are deemed to get assent. This bill are deemed to receive the assent of president. Clear? And if you are forcing such quick assent within 3 months, you are forcing the governor to give assent to the flawed bills, the ill-conceived bills. Like there may be a bill which may say 75% seats of private sector jobs are reserved for the residents of the state. There could be a bill which will say that there will be 3 capitals of the state. Don't you think these all are ill-conceived bills? So governor should be in a hurry to give assent to this bill? No. And if we compare the governor's power with his or her counterpart in USA, we will see that the governor power is now further restricted, further reduced. Clear? And one more point you can add, like it's also the example of judicial overreach. See, there are 2 words, judicial activism and judicial overreach. We will discuss in judiciary, right? So what's the difference between that? Judicial activism is a situation in which judiciary exercises its power proactively, or you can say in full-fledged manner. So whatever the power is given by the constitution to judiciary, if judiciary start exercising it in full-fledged manner, then we will say it's the case of judicial activism. But if judiciary exercise the power in over manner, in excessive manner, then we say it's the example of judicial overreach. So what do you think? This is the example of judicial activism or judicial overreach? Overreach. Right? Because judiciary has rewritten the constitution. Clear? So there are certain committees' recommendations so to make sure that governor does not misuse discretionary power. The Sarkaria Commission recommend that governor should be appointed after consulting CM. The outsider should not be appointed. No. In fact, outsiders should be appointed as governor. Right? Then limit governor's role in university, vice chancellor appointment. Governor should appoint on the advice of council administered by CM. Then Punchi Commission says that there should be 6-month time limit within which governor or president has to act on the bill. Then for Article 356, it says that it should be applied only in small part of the state where there such constitutional emergency arises. And governor should act apolitically while discharging its duties. Then Venkatacharya Commission says that a collegium, that is consisting of PM, Home Minister, Lok Sabha Speaker, CM, etc., that should take a call for appointment of governor. Clear? So now, what is the way forward? Time limits should be there, but it should be decided by Constitutional Amendment Act. Right? Governor should record the reasons for giving the assent and withholding the assent. And we need to now clearly define the scope of discretionary power. We need to define the limits of discretionary power of the governor. How? Through Constitutional Amendment Act, right? And there should be impeachment process for removal of governor if governor act politically, right? And there should be clear rules regarding how the president rule could be imposed. So we need to put limits also on the exercise of president rule power by the president, right? Clear? So basically, we need to tighten the discretionary power of governor, be it reservation of bill for the president or for recommending president rule, etc. But that should be done through Constitutional Amendment Act, not through judicial verdict.